U.S. Supreme Court has ruled a Texas psychiatric prison inmate from Wichita Falls can sue 6 prison officers after the inmate filed a complaint.
Trent Taylor alleges that he was left for days in a cell in a Lubbock prison unit covered in either feces or sewage. He is currently serving prison time for charges of injury to an elderly person and aggravated robbery received in Wichita Falls.
Yeah, PJ Green spoke with Taylor's fiance and his lawyer and brings us the details of this case.
Everything from the windows to the floor was covered in feces.
Trent Taylor is currently in the John B. Connolly unit in Kennedy, Texas, serving time for injury to an elderly person and aggravated robbery. Taylor was an inmate at the John T. Montford Psychiatric Facility unit in Lubbock in 2013. While he was there, Taylor alleges from September 6th to November 5th, 6 of those days, he was forced to live in cells that were covered in either feces or sewage. His fiancée, Maria Rios, is sharing what he's told her.
He would ask for something to drink, he would ask for a shower, he would ask for them to relocate him, and he was met with derision. They laughed at him, they ignored him.
Because of the alleged cell conditions and behavior of prison officers, Trent filed a lawsuit on his own in 2017 against 6 prison officers and lost. Taylor then filed a lawsuit with the appellate courts and lost again. After the appellate courts, Taylor's case caught the eye of Samuel Weiss, the founder of prisoner advocacy group Rights Behind Bars. Weiss filed a motion to ask the Supreme Court to take Taylor's case, and that was also denied.
But from there, I was able to partner with an elite law firm here in Washington, D.C., and we worked together to write a petition of certiorari to the Supreme Court, which it's been considering ever since it came back in session at the end of September.
On November 2nd, the Supreme Court then ruled in favor of Taylor, reversing the appellate court's decision and now allowing Taylor to sue. The reason that Taylor was denied by these courts is because the officers were protected by qualified immunity, a legal doctrine that protects public officials from civil cases and only allows lawsuits where violations of constitutional rights are clear.
There is still value in this idea that if actions are obviously unconstitutional, there doesn't need to be an identical precedent on point to deny a defendant qualified immunity. And that goes for a prison guard, but it also goes for a police officer.
It's affecting people of all colors, all races. And it is something that should have limitations, because no one should be treated like that, ever.
The case will now go in front of a jury. Since Rights Behind Bars is in Washington, D.C., Weiss can't practice in the Texas federal courts unless they have another Texas lawyer. That's the next step.
And we're hoping with the publicity from the Supreme Court case that we will find a Texas lawyer who will partner with us on the trial, and then we'll be able to represent in the trial.
Taylor and Rio say that Weiss and his group have been a big help in their case. And although the battle has been long and tough, they are not giving up.
You know, he's been fighting 7 or 8 years on this case, and he has fought way too hard, you know, with and without representation to let it go.